Okay. Hello and welcome back to our very final session of Alt Legal Connect. This session is Go with the Current, Recent Changes in IP Law. My name is Bree Van Til. I am the Director of Education at Alt Legal, and for the next, hour and a half, 2 hours, I'm still your Master of Ceremonies for Alt Legal Connect. I'm still here to make sure you have a great time, so let me know how I can make that happen. Do need to remind you very quickly, it's your last chance. Okay, not entirely your last chance. Don't get kicked out by being a jerk. We're not going to do that. So um, continue to be as respectful and kind and thoughtful as you have been throughout. Absolutely have loved seeing you share resources and help one another. You all are my favorites. I heart trademarks, but I think I heart trademark practitioners just as much. So please note, we are offering CLE credit for this session through the state of California. However, that is for live attendance only. If you're watching this via recording, you're still going to learn a ton. I just can't help you get CLE credit for it. So need you hear the entire 70, that is 70 minutes of the presentation. Take note of the code when I provide it to you. Don't trust yourself to remember it. Make sure to put that in the survey that you get. We'll try to remember to put that in the chat, but if we forget, you will see that in the recap email this evening. So put that code in that survey and submit the survey, and then you will get a certificate of attendance in your email box. All right, Alt Legal, still a legal technology company. We're not a law firm. We're not giving you any legal advice. So even if we did, you shouldn't listen to it because I'm not a lawyer. So the views that you're going to hear represent those of our panel. They may or may not be Alt Legal's views. Don't assume that they are. As always, use the chat. Love to hear it. Love to see your comments. If you have any questions for the panel, please make sure to start those with the word question so that somebody from our team can get those questions over to the panel. All right. I'm really pleased to welcome our speakers, Christine Farley, Tiffany Shimada, and Chris Turk. So Christine is an IP design protection and advertising law professor at American University, where she's been teaching for over 23 years. I have to point out, because this was told to me earlier this week by Eric Perot, who said, quote, she's the reason I'm a trademark lawyer. And I think that he's one of only hundreds of people who would say that about her. Right. Next, we have Tiffany, who's a shareholder at Greenberg Traurig, where she focuses her practice on trademark counseling and clearance. In addition to other fields and industries she works in, Tiffany also works in the business on marketing, advertisement, and sweepstakes promotions law. So maybe she has some things to say about the raffle drawing that we're going to have at the happy hour after this session. Hopefully nothing negative that she has to say for us about how we're doing this. But that's going to be after the post-session discussion and after the closing remarks at the end. So make sure to join us for that. And finally, we have Chris, who's a partner at Fisher Broyles, where he helps clients with trademarks, copyrights, trade secrets, and all sorts of non-patent IP issues. Over the course of his 20-year career, he's worked for firms and in-house teams, including VF Corporation, which you'll see might be a little bit relevant for this. Um, and he started out as a trademark examiner at the USPTO. It's been a minute, but he knows tons of stuff about that. Here is our panel.
Great. I guess I'm up first. Thank you all for staying with us until this late hour. But there's some really interesting developments in IP law happening right now, so I think we'll keep your attention. I'm choosing to focus on fair use because there are some interesting pending cases in fair use, both in copyright and trademark. And I thought it might be interesting to kind of put them side by side. So I'll start with the copyright case, which is pending before the Supreme Court, the Andy Warhol Foundation versus Goldsmith. And the pictures that I'm showing you there are the Goldsmith photograph and one of the Andy Warhol works at issue. This is Lynn Goldsmith. She's a very celebrated professional photographer, and she's known for her portrait work and especially known for her portraits of musicians. And I just took some of these from her website to show you all the famous people that she's took just wonderful pictures of. She did a series of photographs of Prince on assignment. I want to get these facts right. On assignment from Newsweek in 1981. Prince came to her studio. He was very uncomfortable and he stayed only a short while. And so she didn't even get into her color photography, which she traditionally does after warming up with black and white. So she only got a small number of shots of Prince, and this was one of them. And the next artist involved is Andy Warhol. So unbeknownst to Lynn Goldsmith, her licensing agency had licensed that work that I just showed you to Vanity Fair, which in turn hired Andy Warhol to do an illustration for a story they were doing on Prince for a 1984 article in Vanity Fair. This was the work that Vanity Fair published. This is how it looked in the publication. And Lynn Goldsmith never knew about it. She never knew that Andy Warhol had created this work based on her work. Then after Prince died I should know this, in 2016, Condé Nast, who is the parent company for Vanity Fair, published a commemorative magazine dedicated to Prince. And someone remembered that Warhol had done an illustration of Prince and went back to the Warhol Foundation, because Andy Warhol had died in 1987, and found that Andy Warhol had not just created the one artwork that was in the Vanity Fair magazine, but had created, in fact, 16 distinct artworks based on the photograph. So there was one that was published, and here are some of the others. Lynn Goldsmith only found out about the Andy Warhol's use of her work in 2016, and after having some conversations with the Andy Warhol Foundation, and when she found out about these other works, she sued. 12 of the 16 works had been sold, and the others were then owned by the Andy Warhol Foundation. So here is a pretty good side-by-side to help you think about how the district court, the Second Circuit Court of Appeals, and Supreme Court might be thinking about this fair use issue. The district court ruled on summary judgment in favor of the Warhol Foundation. The Second Circuit Court of Appeals reversed and found that all four factors of the fair use test favored Goldsmith. This is now pending before the Supreme Court. They heard arguments in October, and we await their decision. I have no clues as to when it's going to come out. But I think I went to the oral arguments. It was fascinating. I think the decision will teach us a number of things, or at least be interesting on a number of fronts. Number one is the fact that the court has taken yet another fair use case after only deciding the Google versus Oracle case a few years ago. One may wonder why the Supreme Court thought they needed to opine on these four factors again. So I think a lot of people will be watching to see what the Supreme Court says now that Justice Breyer is no longer on the court, to see how closely these two decisions line up, or whether the court might sound a little different now that Breyer is not a member of the court, and whether it might retreat a little bit from what it said about fair use in Google versus Oracle. Another interesting point that I think people will be watching is that this court really starkly raises the question of the relationship between derivative rights under copyright and fair use. And the lawyer for Goldsmith made a lot of this in the oral arguments, and certainly there were lots of amicus briefs really focusing on this point. That the idea being that this work is licensed, and it might be licensed exactly as it was licensed by Vanity Fair for an artist reference, so that someone might make a derivative work from it. So when we look at these Andy Warhol prints, are we looking at derivative works, or are we looking at a fair use based on the original? So dividing that line, I think, is squarely before the court. This is something different than in Google versus Oracle. So I think all eyes will be on that. And I got no clues from the oral argument about how the court might be thinking about that. And then finally, something I'm always interested in is how will the court navigate the question of Andy Warhol's prominence of an artist in this case? How do you judge these works, and to what extent does it matter that these are Andy Warhol's works hanging in the balance? So that sounds a little simplistic, but I think this was one of the issues that weighed heavily on the Second Circuit. So the Second Circuit was very explicit in stating that they were doing a side-by-side analysis, right? They were judging the works on their own. And when putting these works side by side, and I'm leaving the screen here so you can do it yourselves, they saw very clearly the resemblance. They saw the photographer's work of Prince was very recognizable, the Second Circuit said, in the Andy Warhol works. And they were looking again side by side to see whether the original work had been transformed under the transformative use analysis, to see whether Andy Warhol had created a new message or meaning in his works. And the Second Circuit found that there was no such new message or meaning. The Second Circuit was very hesitant to listen to a lot of art historical expert testimony and have that work its way into the analysis of whether they could see for themselves a new message or meaning. And again, the lawyer for Goldsmith made a lot of this in oral argument in saying, this is not, we're not in judgment of Andy Warhol. You can't just Andy Warholize somebody else's work, right? Just because Andy Warhol touched it doesn't mean, there's a free pass. So I think this always bedevils courts to know how much do we speak like an art historian and say, well, Andy Warhol's work is really about fill in the blank, and therefore, because we know Andy Warhol's work is really about this, then we know there obviously must be a message, even though it might be a message that we or a jury wouldn't be able to see. So I think those are the three big issues that are before the court. Let me see if I want to just say something more about that. Yeah, there was a lot in the Google v. Oracle case. There were a lot of new and interesting things that came out of that case about fair use, and some of it was about the purpose and character of the use, which is the first factor. The court talked about purpose and character in terms of the benefits to programmers and end users as being the way you might think about purpose and character of the use, meaning the court was concerned with audience benefits. And so I wonder in particular whether that might be something that the Supreme Court takes up again or refutes. So I think in that Google v. Oracle case, there was a great distance between Justice Breyer's analysis of fair use and Justice Thomas's analysis of fair use. Justice Thomas wrote a dissent in Google, and even said in Google, made reference to the exclusive rights to prepare derivative works, and said that, you know, Google was profiting from the exploitation of copyrighted material without paying the customary price. And I think one might think the same criticism could be leveled against Warhol. So I went to the oral argument. I didn't really see which of these views from the Supreme Court was going to predominate. So I would have to wait and see on that one, I'd say. Okay, then here I have, belatedly, here are the fair use factors. I think you know them. All right, let's move to fair use in trademark law. So the Supreme Court is going to take up fair use in trademark law. Argument has not yet happened. It's now scheduled for March 22nd. And there you have this much discussed, quite accessible trademark case that Jack Daniels brought against VIP products. This case raises a particular doctrine in trademark fair use law, and that is the Rogers versus Grimaldi test. So this was a test that the Second Circuit made up in a case in which a Frederick Fellini film had used Ginger Rogers' name in the title of a movie in which the main characters portrayed Fred and Ginger on stage. And the Second Circuit had an easy time in saying, this, you know, we have to be protective of First Amendment protected speech in trademark law. And the court said there that the traditional likelihood of confusion case does not apply if the use of the mark bears no artistic relevance to the underlying work whatsoever, or the use of the mark explicitly misleads as to the content of the work. If one of those things is present, right, there's no artistic relevance or it explicitly misleads, then we'll go to the likelihood of confusion test. But we shouldn't go to the likelihood of confusion test in a case in which there is artistic relevance and it does not explicitly mislead, because it would unduly burden speech, and it wouldn't be appropriately protective of speech. So this is the test that the Second Circuit made up, and itself hasn't really followed that test so carefully. Instead, the Second Circuit has latched on to other language in the decision talking about balancing speech rights versus trademark rights. The Ninth Circuit, however, has gotten on board with the Rogers versus Grimaldi test and applied it in a number of settings. Here in Mattel versus MCA, it was applied to a song. A song was an artistic work in which the mark was artistically related and not explicitly misleading. In ESS Entertainment, it was applied in the case of a video game. In another circuit, going outside the Ninth Circuit, it was applied in the case of paintings. These were expressive works. Back to the Ninth Circuit for a television show as an expressive work. And finally, in the Ninth Circuit, applying the test in a case of greeting cards as expressive works, the one Ninth Circuit case that found for the plaintiff, not for the defendant. So this case, I think people are talking about and are interested in, and the Supreme Court probably took because of the question of whether the dog toy in this case really fits this model, right? It's not exactly like a painting or a television show or even a greeting card. So I have here just a lot of images I found online. It seems like there's an awful lot of interest in doing parody in dog toys. I don't know why. Dogs have great senses of humor, I suppose. So but are these works expressive works, right? So here this question is pushing at the boundaries of the test, some may say, and that may have been the Supreme Court's interest in the case. And there are other cases waiting in the wings for which this is the central question. So in another case that's pending in the Second Circuit, Vans sued the arts collective called Mischief for making this shoe on the bottom, which they call the Wavy Baby. And Mischief defends itself by saying, this is a work of art, and we are engaged in artistic speech. There's a critique and a commentary of Vans in particular, the shoe industry writ large. And so we should have the benefit of the Rogers versus Grimaldi test. The Second Circuit said, well, we'll wait and see what the Supreme Court says. We'll come back to you. Just to give you a flavor of Mischief, Mischief had previously done versions of Nike shoes. The picture with red and the picture with the blue background is the Jesus shoe that they did. And Nike was silent with regard to that shoe. But then when Mischief did the Satan shoe, Nike sued them. And Mischief again said, this is artistic, this is artistic work, this is artistic speech. We have a point to make, and we should be protected. More flavor of Mischief. They like to antagonize trademark owners. This was the cease and desist Grand Prix that they did, where they gave some award to people who bought the shirts for the company who was the first to send them a cease and desist letter. And Subway won that prize. They were the first ones, although Subway was very playful when they did send the cease and desist. So I think Mischief is doing very interesting work. They're definitely coming up close to the line in trademark law, and that case pens while we wait. So I want to try to tease this out a little bit in terms of an expressive work. So here's a kind of a parody of a famous trademark. And I've actually created this picture. Maybe such a t-shirt is sold. I couldn't find it. But if it were on a t-shirt, how would we view that parody? Would that be an expressive work? Or would we think of this as, a cheap t-shirt? It's a piece of merchandise. So it's not quite like the painting and the movie and the film and the television show and the song. And so this is really, I think, one of the ways people are looking at this case is that this is a question of the medium, right? We care what the medium is. Is a dog toy more like a song? Is it more like a can of peas that you don't really get as much room to speak on a can of peas as you do in a song? Is there some tertium quid middle section of expressive merchandise that's not quite expressive, works, but not quite a can of peas either? Or maybe it's none of the above, right? Maybe the court will tell us this is the wrong set of questions. We shouldn't be asking about the work. We should be asking about the speech itself. And it doesn't matter whether the speech is on a squeaky plastic dog toy or within a song. We're going to judge the speech on its own. So I think it's this question of how much we stick to the way Rogers versus Grimaldi has been articulated is the question teed up there. Another case which is pending but not being held for the Jack Daniels case is this other case, which maybe people in the audience know there's been an update, but I quickly looked and I didn't see one. Has there been an update? Tiffany's nodding. Okay, then I'm gonna pass the mic. But yeah, so this went to trial as of yesterday. There had not been a jury verdict. But again, the question here was, in the case of an NFT, could the defendant claim that he was engaged in artistic speech? So he was selling NFTs that were called Birkins, that were in the shape of the Birkin bag, and in some cases, the NFT sold for as much as the Birkin bag did. And he said, I'm engaged in artistic speech, and he had a story about the critique he was making. And so again, this kind of raises the medium versus the message question about whether Rogers versus Grimaldi applied. And it seemed to me, reading the tea leaves, that the judge was skeptical of those claims. And it seemed from what the jury was asking yesterday that it was also skeptical of it. It was confused about the Rogers versus Grimaldi test. It couldn't, at least yesterday, reach a decision on that, but had reached a decision on all of Hermes' claims. So that, I think, does not bode well for Hermes. But I think I'm out of my time. So I will pass the mic. And if somebody has an update on that Hermes case, I would love to hear about it. Thank you.
I do. Thank you so much, Christine. I do have a quick update on that Hermes. The jury did hold in favor of Hermes, that there was infringement. And I haven't had a chance to read the decision, but certainly we'll be watching the case closely because it'll affect all the other cases that you discussed today. All right. Thank you so much. Well, I'm so excited to be with you. My name is Tiffany Shimada again. I am a shareholder in Greenberg Traurig Salt Lake City, Utah office. And let's dig in. We have a lot of cases to discuss still. This is another case. It originally came out of the 10th Circuit. And so it certainly caught my eye. It was filed in the Western District of Oklahoma by Hetronic International Inc., which is a US company. And this company manufactures radio remote controls for heavy duty construction equipment like cranes and such. And the defendants in the district court case included European distributors of Hetronic's products. And so they were already licensees and already had a relationship. But they had asserted through a review of an old R&D agreement that they actually own the IP. So they started to manufacture identical products, and these identical products carried identical marks. Now, the jury in the district court case awarded Hetronic over $100 million in damages, most of which related to trademark infringement. Further, the district court awarded Hetronics a worldwide injunction, and this injunction barred the defendants from selling their products, again, all over the world. Now, the defendants ignored the injunction, mostly based on the idea that the Lanham Act could not be applied extraterritorially to their conduct. So the 10th Circuit took this case on appeal to focus on that issue, the issue of injunctions on foreign defendants under the Lanham Act. And this is the first time that the 10th Circuit had addressed this issue. So they went through it very carefully. And I'm going to walk through it carefully with you today because this case is now before the Supreme Court on a circuit split. So the 10th Circuit found that the court had personal jurisdiction over these foreign defendants, mostly because of the contracts that they had entered into. There was a forum selection clause that roped in most of these defendants, as well as their successors in interest, including Abitron. And then the court had found personal jurisdiction over the remaining defendants because of the long-arm statute. You may remember Federal Rule of Civil Procedure 4K2. But what I want to talk about in the meat of this case is the focus on the reach of injunctions under the Lanham Act against foreign defendants. Now, this case offers a deep review of, again, there's this three-way circuit split in the United States. And a little history here. The Supreme Court had already addressed the extraterritoriality of the Lanham Act back in 1952 in a case called Seal versus Bulova Watch Company. And the court held in that case that the Lanham Act could apply abroad, at least in some circumstances, but the facts of that case were a little different. Further, there wasn't a test as to when such an injunction would be appropriate. But in Steele, the defendant was an American citizen who operated a watch business in Texas. He then decided to move to Mexico. He filed a trademark and registered it for Bulova in Mexico, received a trademark registration, imported the watch pieces from Switzerland, and sold the watches in Mexico under the Bulova mark. Bulova recognized this, canceled the trademark registration in Mexico, and then sought relief in the US under the Lanham Act. And the court found that the Lanham Act could apply for numerous reasons. One, you've got a U.S. citizen, and you can apply, Congress has the power to prevent unfair trade practices in foreign commerce by U.S. citizens, even if their actions occur entirely abroad. And two, the court said, well, when the defendant's operations and the effects of their operations aren't limited to a foreign nation, then of course the Lanham Act can apply, particularly where here you've got these fake watches that are flowing through the market from Mexico to the US and damage Bullova's reputation both in Mexico and the US. And so after Steele, the US Courts of Appeals adopted many different tests. The 10th Circuit, though, decided to base its decision in this Heatronics case over the McBee test, which came from the First Circuit. And the McBee test borrows heavily from antitrust law. Under McBee, we must first determine whether the defendant is a U.S. citizen, because a separate constitutional basis for jurisdiction may exist for control of activities, even for foreign activities by a U.S. citizen. And then second, we look at the reach of when a plaintiff seeks damages based on foreign activities of foreign defendants. Here, the Lanham Act only applies if the activities have a substantial effect on U.S. commerce. So the 10th Circuit felt that this test best aligns extraterritoriality of the Lanham Act with both the Supreme Court's antitrust jurisprudence and general principles of foreign relations law. But the 10th Circuit adopted the McBee test with one caveat, that they also consider whether applying the Lanham Act extraterritorially would create conflict with trademark rights established under relevant foreign laws. So in effect, a court should weigh the plaintiff's rights under the Lanham Act against a defendant's foreign trademark rights established by the defendant. Now we'll briefly talk about the two other tests that are followed. The Vanity Fair test comes from the Second Circuit, but is also followed by the 4th, 5th, 11th, and Federal Circuit courts. And it looks at three different factors. One, whether the defendant's conduct had a substantial effect on U.S. commerce. Two, whether the defendant was a U.S. citizen. And three, whether there's a conflict with trademark rights established under the relevant foreign law. Well, this test is followed exactly to the T by the 11th and Federal Circuit courts, but the 4th and 5th have each tweaked the first prong. The 4th Circuit has substituted substantial effect for a significant effect. And then the 5th Circuit lowers the bar even further to just require that there be some effect on U.S. commerce. The third test that's followed widely is the Timberlane test, and the Timberlane test comes out of the 9th Circuit. We consider three distinct factors as well here in this test. One, whether the violations create some effect on U.S. commerce, so again, a lower bar. Two, the effect is sufficiently great to present a cognizable injury to the plaintiffs under the Lanham Act. And three, the interest of and links to American foreign commerce are sufficiently strong in relation to those of other countries to justify asserting extraterritorial reach and authority. Now, the Timberlane test goes on under that third factor to determine whether or not there's international comity. And there are 7 additional factors, which we won't address here today. But applying the modified McBee test, the 10th Circuit affirmed the application of the Lanham Act, again, against the defendants for all of the product sales, because they had, prevented foreign revenue from flowing into the U.S. economy. But the circuit court also found that the district court's worldwide injunction was just way too broad. It covered all countries, even those countries where Heatronic does not sell or market its products. So they narrowed the injunction to just the countries where Heatronics had, sold or marketed its products, and remanded the case to the district court on that point. Well, shortly after Abitron and the other defendants petitioned the Supreme Court to review the case, they claim that of the $90 million plus in damages that was awarded to Heatronics under the Lanham Act, 97% of those sales were strictly between foreign sellers and foreign buyers. That therefore, for those sales alone, there never was a U.S. confusion or any harm that might have reached the U.S. And so this is the question that they presented on the slide before the U.S. Supreme Court. The Solicitor General argues that the court should apply its current two-step test for a presumption against extraterritoriality of the Lanham Act, and that it should only apply if the mark abroad is likely to cause confusion in the U.S. So we'll see how this comes out. The case is up for oral arguments. I'm going ahead too quickly. The case is up for oral argument on March 21st, so we will know very, very soon how the Supreme Court sees the extraterritoriality of the Lanham Act. Now we'll move to the second case I'd like to discuss today. It's a great roadmap for trademark practitioners, so I just want to walk through this one with you too. It's In re Jasmine Larian. This case was decided in early 2022, and then it was later redesignated as precedential before the U.S. Trademark Trial and Appeal Board. And in this case, Ms. Larian, she's the owner of a brand called Cult Gaia. And at the time, back in like 2017, she had the It Bag. It's an ARC handbag, and she had tried to register this bag, the product configuration of the bag. So not the handbag itself or the brand of the handbag, but the product configuration. And I'll show you the drawing that she submitted here on the left, and then the mark description on the right in the application. Now, the board first found that the mark was properly refused by the examiner as generic under the genericness test. And the genericness test, remember, it first looks at the genus of the goods. And so here we have handbags as the genus. And then it asks whether the relevant consuming public, which in this case are ordinary consumers who buy handbags, would consider the design to be a category or a type of trade dress for the genus of the goods. And in effect, if the product design is so common that it can't be said to identify a particular source, then it must be refused registration because it fails to function as a mark. Well, the board considered all of the evidence of record, and this is where this case gets really juicy because there was so much evidence. Most persuasive were third-party articles and lots of good content, blogs and magazine articles where similar handbags or identical handbags were sold. And this is well before the plaintiff or the applicant's first use date of 2013. The board also pointed to nearly identical bags sold on Etsy and Amazon.com to show that these were not unique or source indicative of Cult Gaia. Also compelling were statements made by the applicant herself. On her website, she had said that the bag was a reproduction of a classic Japanese picnic bag and that it was inspired by a vintage bamboo bag that she had found. And again, she made these comments on her website to reporters. There was an informational card actually sold with the handbags that stated it was a reproduction of a classic Japanese picnic bag. So all of this, of course, worked against her. Also, the court looked at evidence from museum exhibits and books, fashion history books, that detailed the historical nature of the bag as a Japanese lunch bag. There were also comments from experts and bloggers claiming that this bag was not original, that it was a long-standing design, and people had found them in their mother's closets. So this bag had been everywhere, and there was a wealth of evidence to show on blogs and historical records as well to point to that. So given all this evidence, the board deemed the design generic, and the same evidence also worked against the applicant's claims of acquired distinctiveness in the alternative. So importantly, the applicant had tried to use YouTube videos and comments from reviewers to support her claims of acquired distinctiveness. But then she also disputed that same type of evidence offered by the examiner to show that her bag was generic. The board didn't like that. They thought that, what's good, and they actually said, what's good for the goose is what's good for the gander. She couldn't use similar evidence to support acquired distinctiveness and then dispute that same type of evidence as inappropriate for the genericness refusal. And so the board looked at these 6 converse factors under the acquired distinctiveness test and weighed each factor carefully. She didn't present any survey evidence, which is where you would show an actual association. So the board skipped on to factor 2, which is the length, degree, and exclusivity of use. And with that, they found that there was significant coexistence, again, pre-2013, to cut against any exclusivity of such use, even though she had used it for a long period of time. For the amount and manner of advertising, the board noted that applicants' marketing prowess and promoting the handbags on social media was great. But there was no look for advertising, which is really what you want to see with an acquired distinctiveness claim in product configuration. And despite having the total sales of over $12 million under the 4th factor, the board found that there was insufficient context of those sales to the market as a whole. So we don't know what her market share was, or, even though those sales were significant, what they meant to handbags in general, to put them in context and to say that it was significant enough. With regard to intentional copying and policing, the evidence was found to be very vague to be persuasive enough. The enforcement evidence that was presented referred more to use of unauthorized use of ARC or of Colt Gaia itself, so the word marks that were associated with the bags, and not so much the copying of the configuration. And so the boards found that, there's no evidence of demand letters or settlement agreements with regard to the product configuration to corroborate her enforcement efforts. And then finally, we look at significant media coverage of the product, which there was. It was an it bag. It was very much all over the place. But against all these other factors, it was outweighed. And the board held that in the alternative, that there was no acquired distinctiveness. And so again, this case is a great case. It's a great study for the type of evidence that you need to show acquired distinctiveness, and also to beat a genericness claim for product configuration. Now, this third case is another U.S. Supreme Court case that from 2022. This is a copyright case, Unicolors versus H&M. Unicolors is an apparel company out of LA, and they create these fabric designs for exclusive and the public customers. And in 2011, they had applied for and obtained a copyright registration and a collection of 31 different designs. And one of those designs was a 2-dimensional artwork entitled EH101. And it's got triangles and lines and looks like a very busy, happy pattern. And in 2015, H&M sold a skirt and a jacket set that incorporated this EH101 design. Now, in 2017, Unicolors sued H&M in the U.S. District Court for the Central District of California for copyright infringement concerning several of its designs, including this EH101. In its defense, H&M argued that Unicolors' registration was invalid because they had applied for multiple works at once where they were not in the same unit of publication. And that was a requirement to register multiple works. Now, the date of first publication in the application was listed as January 15th, 2011. And yes, on that date, Unicolors had made some of the designs available for sale exclusively to certain customers, and then offered the rest to the general public. Now, Unicolors asserted that the safe harbor provision, which is Section 411(b)(1) of the Copyright Act, states that a certificate of registration is still valid regardless of whether the certificate contains inaccurate information, unless 1, there was knowledge that the information was inaccurate, and 2, the inaccurate information, if it were known, would have caused the copyright registrar to refuse registration. Now, the jury ruled in favor of Unicolors. They found H&M had infringed the copyright in EH101, and that the registration was valid under the safe harbor provision because, they weren't aware, Unicolors wasn't aware that this whole unit of publication requirement it needed to be. On appeal, the Ninth Circuit reversed. They held it doesn't matter whether Unicolors was aware of the requirement because the safe harbor only applied to only excuses mistakes of fact and not of law. And so the case was remanded back to the district court to make an inquiry under the second prong of the safe harbor test, to ask whether it would have been refused had the copyright register known about the failure of the application to meet that same unit of publication requirement. Well, Unicolors then requested review by the Supreme Court after the Ninth Circuit's decision. They asked whether the Ninth Circuit had erred in referring the case to the Copyright Office where there's no fraud, there's no material error, and where the Ninth Circuit had misapplied the publication standard because it wasn't in place at the time that the lawsuit was filed. Well, the Supreme Court found the safe harbor still applied as to both mistakes and law, mistakes of law and fact. They looked really at the meaning of knowledge, and they looked at it as it has been applied elsewhere in the Copyright Act. And what they found was that it applies to both. It applies to both legal and factual knowledge. And the policy behind the safe harbor is to protect applicants from both types of mistakes when they have made those mistakes in good faith, right? So I think this case was perceived by most practitioners as positive for copyright registrants who've made small mistakes, particularly those who are not using attorneys to file their applications. And it does excuse those small facts or misunderstandings of facts or the law that are made, again, in good faith. If they're made in bad faith, that's a different story. But it does keep the safe harbor intact for all of those applicants. And now I will turn it over to Chris for the rest of the presentation.
Hello, everyone. When I was speaking with Bree about what topics I could and should cover, I said to her, I'm in awe of law professors like Christine. I contemplated getting a PhD in history, and academia is not for me, so I became a trademark attorney. And I love the history of trademarks, though. And so we're via email batting topics back and forth. And I said, prosecution, having been an examiner, worked for a law firm, been in-house managing a team, I said, solving prosecution problems is what I enjoy most about my law practice right now. And she said, well, how about some of these ideas? And so that's what we're going to focus on today. And I know our presentation sort of recent changes in IP law. I titled my portion "Practice Tips on the Cutting Edge?" kind of facetiously, because none of this is really new, but there's some recent changes in IP law that I think have brought us back to the way things used to be, or are moving us in a new direction. So the first one is the new office action response deadlines that the USPTO trotted out in December of 2022, which is we now have 3 months to respond to an office action. And sure, there are benefits and there are drawbacks to that. I don't know about you, but it is taking me some time to get used to this. Now, there is one 3-month extension available for a fee. Some cynics would say that the PTO is just doing it for money, but I think it is a good way it's a carrot to get us to try to respond in a more quick or agile manner. So what does this mean for trademark practitioners from a practical point of view? We're going to need to be more responsive, obviously. Deadlines come a lot sooner. You need to report this to your clients much quicker. If you haven't been reporting it, within a week. Some would say that's too long. I have a partner that says you should report office actions within a month. Once you're hitting a month, you're looking at frowns from firm management, maybe malpractice carriers, etc. So we need to be more responsive. Shoot for a week. I mentioned firm management. We recently internally, I don't want to share everything that was said internally, but the trademark group recently had a call with our firm's general counsel about many issues, but about this in particular. I represent a lot of small sole proprietors, very small businesses. And I often have to chase them 3, 4, 5 times to get instructions on how to respond to an office action. It's easier dealing with foreign associates or an established trademark or IP department at a large company. But when you're chasing these small clients, how many times do you have to do it? How many times is enough? When is the first time? When is the last time? Our counsel had advised that 2 months before our deadline, this was before the 3-month deadline went into effect, that we start the process of looking into withdrawing as counsel. We didn't want to be on the hook if the deadline came and we had not been instructed. With a 3-month deadline, that's simply not practical. So what to do? How many times do you have to contact the client? When is the first time? When is the last time? These are all things that need to be considered with this new 3-month deadline. Ultimately, I think, I say this as a former examiner and again, as a practitioner who sometimes wants the PTO to move more quickly. This is going to help eventually. But as I touch on in a later section in the presentation, there's some concern right now, I think, that while pendency is very high, this is putting more pressure on the PTO to rush through things. But we'll see how it turns out. As Bree mentioned, I too am touching on Vans versus Mischief. Not from the legal aspect that Christine looked at, but from a practical aspect. As Bree said, I used to work for the company that owns Vans. And all this occurred after I left, so I feel comfortable talking about it. I can only assume that Vans was and is apoplectic about this, about Mischief's shoe, the Wavy Baby. What I want to talk about, though, is if Mischief came to me today and said, how do we avoid getting in trouble? Now, maybe there's no way to avoid it. We'll see what the court says, what the Second Circuit says. But in the grander picture of how to avoid copying, I wanted to touch upon my experience advising Vans and other clothing brands and footwear brands. I often had the pleasure when I was at VF Corporation of sitting in design rooms with designers and looking at, T-shirts hanging on walls from other brands and fabric swatches and Pantone books and, all your competitors' goods and, picking, I like that from there and I like that from there, and we want to combine them. And that used to strike fear in my heart. I could feel my heart pounding, like, this is not good. So what is the practical solution? What would I advise them? And this is what I used to advise them, which is, hey, it's great that you have everything hanging on your walls. We can't stop you from going out and buying Adidas or Keds, other brands that Vans took, I use air quotes, inspiration from, because everybody is inspired by and takes inspiration from other brands. But how do you avoid the willfulness, the intentional damages, that could be at stake if there's evidence showing you knowingly copied? And so what I said was, and this is what I advised clients then, I advise them now, is go into a sterile room, create a different room where you do your drawing and designing. Don't have it hanging in front of you, like the picture on the left, as you sit down at your desk to design. Separate the creative inspiration from the design element. And I don't know if those of you in the copyright and trademark practice, particularly the copyright practice, have ever heard this, but maybe Christine will get a kick out of this. I've heard lots of different rules, like if you only copy 10%, you're fine. Or if it's in color and yours is in black and white, you're fine. There's no such rules. There aren't any rules. I'm paraphrasing one circuit court judge that said, copyright law is what I say it is. Or in this case, it is what I decide it is. And so don't get caught by having intentionality brought to light because you sit in a room copying. And I'm not saying that's what Mischief did. Theirs is a slightly different case, but how to avoid something like that is create a sterile room. That's my practical solution. And like I said, I advise clients to do it that way today. Another thing that has popped up recently, again, and it never went away, but is avoiding genericide. Bree was very kind when she said, I've been practicing for 20 years. I joined the trademark office in 1998, so we're coming up on 25 years of IP practice. And I remember we went to boot camp. We went to 6 weeks of training before we were probationary examiners. And it was hammered into us. You don't Xerox something. You make a copy with a Xerox machine. And we were shown an ad. I could not find the ad on YouTube, though I did find some incredibly sexist Xerox ads from the 1970s about have your secretary do your copying for you, don't do your Xeroxing, etc. But on the left is an advertisement that Xerox was placing in the Philippines in newspapers, putting people on notice that Xerox is a trademark and should not be used as a verb. Most recently, Velcro has had a great social media campaign, and they've used it very well to potentially stave off genericization, of Velcro. I mean, we all have heard of various trademarks that have gone to the generic graveyard, including escalator, aspirin. Some of them are wrong. I saw a couple today that various websites that said Thermos is generic. I don't believe so. I think if you look on the USPTO website, it is still registered. Same with Windbreaker is still registered, though it often is used generically. But this is not anything new. This is a letter from the early 1980s, or actually, I believe 1979. And I included this. This is Xerox writing to the New York Times, asking them not to use Xerox or Xeroxed, instead to use copied. One of the brands that VF owns, which I had the pleasure of working on for more than a decade, was the North Face. And I remember being asked to write a letter to the New York Times, very similar to this one, because the North Face is the trademark. It's capital the North Face. It's not North Face, it's the North Face. But try getting the New York Times to say the New York Face, excuse me, the North Face. They won't do it. In fact, they won't even capitalize the in the North Face. So what comes around goes around. Here we are today, dealing with the same issues as we were in 1979. But Velcro has found a way to, in my opinion, use social media to its advantage. In that it's a lot cheaper than, say, running ads on national television. No, I believe they were doing that as well, and Xerox has done that in the past. The problem is social media also allows for just as many, if not more, misuses than, say, the New York Times and people using Xerox as a verb in presentations. Social media has allowed us all to be content creators. So the misuse can be even greater, though Velcro is using social media to its advantage to combat that. I tell clients now, when they say it's going to cost me money to do that, whether it's buying Google AdWords to advertise their mark as a trademark, as opposed to a generic term. Yes, you have to pay for it, but you're getting 2 for 1. You're educating consumers on how to avoid genericide, while at the same time getting your brand out there. I mean, Velcro is getting double benefit here, and I think it's just a brilliant way to get the point across. As I mentioned before, when talking about the 3-month deadline, I said I'd get to pendency. When I joined the trademark office, pendency was about 7 months for new trademark applications, meaning it was reviewed by an examiner at about the 7-month mark. This was in 1998, 1999, and there was a congressionally mandated, I mean, it wasn't a law. I don't even think it was an official dictate, but Congress had mandated that pendency get down to 3 months. So the examination core was more than doubled. And eventually, I believe it got down to about 3.5 months. The tech bubble burst and pendency rose as examiners were laid off. And I don't know that pendency's ever gotten back down to 3 months. 4 or 5 months, I think, was pretty good. And that was probably, I think, 2 or 3, maybe 4 years ago. Pendency has skyrocketed. As you can see, current trademark processing wait times, it says due to a surge, wait times have increased. And that is true. But I also post an example taken a few days ago from TSDR of a mark that has been pending for almost 2 years now without being examined. It was filed on May 24, 2021, and it has still yet to be examined. And I've spoken to or emailed with the Trademark Policy Office about why this is. And rightfully so, they won't comment to third parties on any specific application. But we're coming up on 2 years and this application hasn't been examined. It was filed by a Chinese applicant. And I mentioned that only because there were 2 orders to show cause that the trademark office issued to, in one case, I believe, 800 or more trademark applicants to show that these were legitimate trademark applications. This one I have for refi does not appear to be. The specimen, if you look at it, appears to be faked, but nothing can be done until it's examined. So why is this important? How does it affect my practice, your practice? What is the effect on clearance? I don't know about you. When I'm reviewing search reports, I consider when applications are facing, when they're going to drop off, so to speak, when they're going to be abandoned. I anticipate when they're going to be abandoned. And that helps me advise my clients. With pendency up the way it is, that has become that much harder. Overcoming refusals, waiting for registrations to drop off. When a registration is in the renewal grace period, I can drag out an office action response. I can file something that's slightly better than the bare minimum, which will get us past that deadline, fingers crossed. Prior pending applications that have yet to be examined because of high pendency. Does that affect your clearance? I know it affects mine. And then the double threat with the 3-month deadline, we have to respond to things sooner. So when the PTO is not examining things as quickly as possible, or I should say as quickly as they were before, it does make the job somewhat more difficult. So we have to be creative. Again, you can still seek a 3-month extension to the 3-month response deadline. It doesn't really help you when you're reviewing search reports, but the PTO has promised they will get pendency down. And I see Bree has come back on our screen. I think it's time to wrap up. So that was.
I was just here for the code. We still got about 3 minutes left, so Don't worry. Our CLE code is the number 3, the word update, as in what you just got, and the number 5. That is 3, update 5. You have about 2 minutes remaining. If you want to go ahead and take a couple of questions or finish up with some final thoughts. If not, we can take those directly into the post-session discussion.
I apologize. When I saw you pop back up, I forgot that.
Yeah, I saw that you
were going to
like
do that.
Rushed out. Yeah.
And so I sped up. So we can go right into the post-session questions.
Okay. All right. Wonderful. Well, then let's go ahead and we'll wrap up here. And let's go into the breakout room for the post-session discussion. It's going to be wonderful. Thank you all so much, panel. We really appreciate it. I feel like we all know a whole lot more about these cases and what they mean and how they're going to affect us. So thank you so very much for that. I really, really appreciate it. It was great to hear from you. Audience, come join us in the post-session discussion. You have about 7 minutes or so to go take a quick bio break, get a drink of water. This was our very last full session of Alt Legal Connect. So, I hope you had a wonderful time, but I do want to see you all in the post-session discussion, and I absolutely want to see everybody in the happy hour that's going to follow it, or the happy hour that's going to follow the closing remarks by Nehal. So stick around. We don't have very much more of Alt Legal Connect left, but go get a drink. I will see you in the post-session discussion in just a couple of minutes.